We don't want the power of attorney to just be able to gift everything to whomever they want. That would be disastrous. Hi, this is Jeff Marsacci, the Plain English Attorney, and welcome to the video. Before we dig into today's topic, please help us get out solid, accurate information on estate planning and Medicaid planning by liking the video and subscribing to the channel. Unfortunately, the algorithms just tend to favor videos that tell people what they want to hear instead of what is actually true. If you want us to get the truth out there about estate and Medicaid planning information, then please like the video and subscribe to the channel. Today, we are going to cover 5 things that a power of attorney can't do. So, in general, power of attorney documents, usually they're distinguished between healthcare and financial. We're going to be talking about the financial one, and there's a lot of misunderstandings around this. People often treat a power of attorney is just something where I can download the form and it's always the same everywhere. And, you get some power of attorney free off the internet, and it's going to be just as good as if an attorney did it and it was customized to your particular situation. Well, there's definitely good and bad. And in fact, in my state of North Carolina, there are, quote, 2 versions. We're going to talk about that in the bonus section, so please stay till the end. So the power of attorney is delegating authority that you have as a person, and you want someone else to be able to handle certain legal, financial, and related tasks on your behalf. So you have to be able to do these things, and therefore you're empowering someone else to do it. So what is the first thing that a power of attorney can't do? And this is a very common thing. If you have a revocable living trust and you have actually funded it properly, meaning you have titled assets and accounts in the name of the trust, and the person on your behalf walks into the bank and says, "Here's the power of attorney for this person. Give me access to their accounts." And they say, "Well, no, we can't. This is a power of attorney for that person, and you can't access those accounts." And I've had this happen with, unfortunately, just some very either misunderstood people, or they just had to find someone to take this out on because they were in a difficult situation of having to handle things for someone else. But they're screaming on the phone that the power of attorney was defective. Well, no. The power of attorney will only access things that you are able to as an individual. Once your assets are in the trust, you're accessing your own accounts because you're the trustee. They didn't bring in the proper paperwork. And this is just a side thing, a tidbit. When we put together a revocable living trust, there's usually a power of attorney. There's also the pour over will. If anything ends up in probate, it sends it to the trust for the actual estate plan. The people who are listed are the same across the board in all of those. So what did this person do wrong? They brought the wrong document. It's kind of like if you buy a car and then you go and you try to open your house with your car keys. You can't go back to the car dealership and start screaming at them that these keys don't work because they didn't open your house. That's the whole point. A power of attorney can't reach into and handle things in a trust any more than someone, just because they're a trustee, can reach outside the confines of the trust and try to do things with accounts or assets or sign tax returns. It's like, well, I'm the trustee. Yeah, but the individual has to do these things. All right, so what's the second thing? And this is actually a case that came by several weeks ago from a longtime client, and he was kind of in a tough spot. Look, he was basically going to be out of the country, and he is listed as an executor on someone else's estate who passed on. He wanted to delegate that authority as the executor, which you can't do because the executorship, that's a court appointed position. You have to actually do that. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. There's no, well, okay, yeah, I'm not available. I want to delegate the powers and authorities and the responsibility to someone else. You can't do that. The court has to do that. Think about it this way, because an executor is an official position. Just imagine if the president of the United States had named their spouse as the power of attorney, and they walk up to the situation room. I've got the power of attorney. I need to go in and order a missile strike against China. You're not authorized to do that, but I have power of attorney. No, it's the source that was delegating the power. You don't have that power as an individual. You only have it. In this example for my client, he was the executor. He couldn't delegate that to someone else. They figured something else out in that particular situation. I believe it's all set. But that's something you can't delegate. You can't delegate powers for a court-appointed position. The only one who can is the court. All right. So along that same line of thinking, you can't delegate business and corporate authority to someone else through a power of attorney. You're not able, if you're, say, the secretary of a corporation, you can't do a personal power of attorney and empower your best friend to make decisions for the company. Okay, yeah, my friend's the one who's going to file these documents and sign these contracts and handle these things as secretary because I am delegating them that authority. You can't do that. Typically, you're going to look into the bylaws or the operating agreements, whatever the situation is, whatever the business position is, and the document describes who should be handling things. If you can't, depending on the document, it may very well be you've got to step aside or have a corporate resolution that can temporarily put someone in place. But that's power of attorney is not the document to do that. All right, moving right along. Fourth one, bank accounts. Sometimes, even if it's titled in your name and you're bringing in a totally valid and legal power of attorney, the bank can still refuse it. Oh my gosh, this is horrible. You shouldn't be able to do that. I agree, you shouldn't be able to do it, but that's the way it is. When you sign up for a bank account, you're signing all of these agreements that go into what the different terms and conditions are, what kind of interest are you looking at. They're going to hold on to your money and they're going to do this with it. You're allowing them to do certain things. And then you get that fine print paperwork either emailed or mailed to you every several months where they've unilaterally updated the agreement, which you gave them permission to do. Like all that is, it's contract. It's a contractual agreement between you and the bank saying, here's how you're going to govern and manage my accounts. Now, somewhere in all of that, there was something that said, we now have our own power of attorney forms, and you must use these power of attorney forms, and the bank reserves the right to reject any other power of attorney forms. Okay, they can. So unfortunately, a perfectly legal, valid power of attorney can be rejected by a bank because it wasn't on their form. And I haven't seen any case law on this where you can actually go and sue the bank. But what the bank typically tells you, if the person's now incapacitated, they can't come in and actually sign the bank form with the power of attorney. Oh, just go ahead and get a guardianship. That's living probate. The whole reason my clients who come to me wanting to set up an estate to avoid probate, they use a revocable living trust. They want to avoid that. And all a guardianship is, it's living probate, because now a court has to empower someone to be that guardian, oversee things, make reports to the court, make sure the money's being managed. And it's just a whole bunch of legal paperwork and a burden on the person handling this stuff for you that they wanted to avoid by setting things up privately the first time. So when I walk through with my clients at a funding meeting, here's how you should be handling your assets in order to get them to work with the overall estate plan and with your revocable living trust. I tell them, look, either you're putting your accounts into the trust and getting things set up, and there's a process for that. I've got a whole funding course on that, trustfundingcourse.com, that walks through that. And if for some reason, and it's legit, I've got way too many automatic deposits and bill pay and all this other stuff coming in, it's going to be a huge frustration moving it into the trust. Well, okay, if you just make that one account pay on death to the trust, when you go into the bank and you do that, make them take and file a copy of your power of attorney. This is where they will either say, okay, fine, and now it's on record and they've got it, or, well, oh, I'm sorry, we can't do that. We've got our own form. Great. Bring the form out and fill it in. This way, you know it isn't going to be a gap. All right. And now this is kind of an obvious one when you really think about it, but I do see this all the time. Oh, when I die, my son can just take the power of attorney down to the bank and go ahead and collect everything. No, 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 absolutely not. A power of attorney, remember at the beginning, it's empowering someone to do something on your behalf that you could do. Once you're deceased, you legally cannot do those transactions. And that's the reason why legally a power of attorney cuts off at the moment of death. And that's it. Now, if someone's trying to do something on your behalf in your individual name after you've deceased, after you've gone to the great beyond, that's when it switches over to, oh, the executor has to do that. And the executor has to start probate. Again, my clients generally want to avoid that, which is why most of the assets are in the trust or pay on death into the trust automatically without the need for probate court. So what exactly is this big bonus? It's the power of attorney is not just some magical document that you can go and purchase from the attorney and it's the same everywhere across the board. Even though some states have form power of attorneys that they put, they're essentially saying, yeah, here's this state approved language, but go ahead, start with that, or go ahead and just use it. North Carolina has two, and unfortunately, I see this all the time. The short form power of attorney. Oh, that's nice and easy, and it's simple. You just initial next to the powers that you want to confer on somebody else. However, remember, when you're dealing with banks, you're dealing with financial institutions, you're dealing in transactions like real estate, where there's a lot of leverage on the other party, they can simply say this isn't good enough. And there have been an awful lot of court cases where a court will say, well, if the power of attorney doesn't explicitly say you can do this specific thing, then we're not going to allow you to do it. And here's the big example: real estate transactions. Okay. Real estate transactions could just simply be buying and selling real estate, but then also it could mean taking out a line of credit against the real estate. It's not in any of those other powers that specifically says that they can go ahead and take money out, open a line of credit and pull money out on your behalf. Well, it's not in the power of attorney, so you can't use it. There's also a long form power of attorney, which basically means, hey, look, all of this stuff is just spelled out in excruciating detail with all of the different things. And that's kind of what we started with our law firm, and we expounded on it as we ended up getting more and more situations. One of the big things that you're not going to find in any typical power of attorney that we do is we put in very specific gifting powers if there's a need for gifting in order to get somebody qualified for long-term care Medicaid. Most of the power of attorney documents that I've seen out there either doesn't allow these gifts or limits it to the federal exclusion and whatnot, blah, blah, blah. But that's where you're talking about taxes. And it's like, well, we don't want the power of attorney to just be able to gift everything to whomever they want. That would be disastrous. Well, then they shouldn't be your power of attorney if you think they're going to do that. Plus, they're doing it on your behalf. So again, having those specific provisions spelled out that this is in order to qualify for Medicaid or other programs, it's important that it's in there. Otherwise, you're not going to be able to make these chess moves in transactions. So yeah, a power of attorney can do an awful lot on your behalf, but there are some things that it's just not going to do. If you have any situations where you had a power of attorney that got rejected and you want more information, go ahead and put it into the comments below. Maybe this is something that we could do a follow-up video on some of these circumstances. But if you want some more information on the whole interplay between a revocable trust, the power of attorney, the pour over will, how does all of that work? Then please check out our free trust course at freetrustcourse.com. Again, freetrustcourse.com, and get that information for free. So, as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.